Hi, I'm Cristin Lowe, and we are back on part 2 of how to file for your divorce. So we've already done the petition, which is form FL-100, taking you back to the home page, back to commonly used forms, and we are going to just march right on to the next form, which is the summons, FL-110. And this form scares a lot of people for a number of reasons, but the first thing you need to understand is it's extremely easy to fill out. It has a lot of content that I want to take the time on, but as far as filling it out, this should take you no more than 5 minutes. So let's start with the notice to respondent. Who is the respondent? The respondent is not you. You are the petitioner. So the respondent would be your spouse's name. So you are going to put your spouse's name, which in this case is Jane Smith. And yes, half of this is in Spanish, so it looks twice as long as it actually is. All right, we're going to go down to the next thing, which is petitioner's name is. And you are the petitioner. So in this case, we have John Smith as the petitioner. So we're carrying over the same theme from our petition, which is FL-100. And yes, the box says you have been sued. And that is a notice to the respondent, or in this case, Jane. And yes, that sounds scary. It sounds like it's a horrible thing. But the reality is that a divorce, just like any other court case, is a lawsuit. This is not plaintiff-defendant. We're using specifically the terms petitioner-respondent because this is not a fault state. This is a no-fault state. It's very simple. All right, so the first page has information for mostly the respondent, in this case Jane, but it's also good for you to be able to read it. Essentially, in a nutshell, what it says is the respondent, or Jane in this case, has 30 days to file a response to the petition once it's been served on her. And if you have any questions, you can read it more fully, and they actually have a website where you can click on it and get more information. So we're going to actually scroll down and get you to the part that you need to actually fill out. And we go back to the name and address of this court, R. And in this case, we're in Contra Costa County, so we have 751 Pine Street, or in this case, we're going to start with Contra Costa County Superior Court. And the Family Law Center is 751 Pine Street, and that's in Martinez, California. And the zip code is 94553. And now, name, address, telephone number of you. So you're not an attorney, but you are the petitioner without an attorney. So you're going to put your name. In this case, it's John Smith. And the address is 124 Rose Street, San Ramon, California, 94582. And just like I said in the petition, you don't need to put your home address, but you do need to put a valid mailing address where the court can reach you. And the phone number in this case, we have 415-442-5577. So when you go to file this, you need to be aware of the court filing hours, which in 2015, it's from 8 a.m. until 1 p.m. Okay, so we are now on page 2 of the summons. There is absolutely nothing for you to fill out, but it is extremely important that you read the summons and you actually understand them. So again, just like the first page, half of it's in Spanish, half of it's in English, so it's not nearly as much reading as you think it is going to be. And yes, there are a lot of scary terms, just like you're being sued on page 1. In this case, you're restrained, so restraining orders. But the first thing I want you to understand is these are not domestic violence restraining orders. We are not saying that you have done anything bad or that your spouse has done anything bad. We're not saying any of that. But what these are, I call them social niceties. These are things that you're not supposed to do and your spouse are not supposed to do between now and the time either the divorce judgment is entered or you two have a written agreement otherwise. So the first one, in case you two have minor children of your marriage, you cannot remove that child from the state of California without written permission from the other parent or a court order. Why? Because we don't want any parental kidnapping. We don't want anyone being scared during this divorce process. Keeping the child in California makes a lot of sense. This does not apply to you. If you have a business trip, feel free to go. If you want to go out for a weekend with your friends, by all means go. It just means your child has to stay here in California. The second restraining order. cashing, borrowing against, canceling, transferring, disposing of, or changing the beneficiaries of any insurance or other policy. That includes life insurance, that includes health insurance, auto insurance, all of the insurance policies that you can think of. Do not change the beneficiaries. Now, there are some companies, if you work for a bigger company, where they won't let you anyway, but I don't want you to try and do anything. And the reason for that is because we don't want somebody without insurance. We don't want to cut the kids off accidentally. We don't want to cut your spouse off accidentally. That's just not nice behavior. So even if you're paying out of pocket, even if you are paying premiums through your paycheck every month, do not change the beneficiaries. It's not nice behavior. You wouldn't want it done to you, so we're going to ask you not to do it to the other person. All right, number 3, transferring, encumbering, hypothecating, concealing, or in any way of disposing of any property, real or personal, without the consent of the other spouse. So this is a tricky one, and probably one that I get questions on all the time. And yes, sometimes it does result in unfair dealings. Can I take my spouse off the credit card? No. Can I take my spouse's name off the bank account? No. Can I sell my stock? No. You are not supposed to do anything outside of the ordinary course of business without your spouse's permission or written consent. And it goes back to being a social nicety. It's something that you need to do. It's the right thing to do. I understand that your credit can get damaged. I understand that there are maybe some unfair ramifications that come with this, but you really need to keep this intact. Courts take violations of these restraining orders very seriously, and it usually costs you a whole lot more to undo what you did. So we kind of want to freeze everything as close to what it looked like during your marriage as possible. And the last one is called creating a non-probate transfer. This is kind of one of those things where it's very unlikely that you're going to do it, but basically what you want to do is you don't want to give away property. That's the best way I can explain it. You don't want to try and cheat your spouse out of what is really joint property or even property in your own name. And you need to notify the other person of any proposed extraordinary expenditures at least 5 days in advance. The pipes break in your house and you're going to have to pay a really large amount of money to replace it. You need to notify your spouse. That's not necessarily permission, but you do need to notify because, again, a lot of times you have to dip into community property money and you need to be notifying the other spouse. You may use community property or your own separate property to pay an attorney to help or for your own court costs. So that is something you can do. So you could theoretically use a community credit card to charge your attorney fees, for example, or to pay your bills. All right, going on, we have AHA information. This is the Affordable Health Care Act. You might have heard of it as Obamacare. This is giving you your notice that you may be eligible for it. Even though you are covered through the restraining order, we call them ATRAs, the automatic temporary restraining orders, or the standard family law restraining orders, you need to be thinking in the future. If you are covered by health insurance by your spouse, this is not going to happen forever. Once the divorce is finalized, you're not related to your spouse anymore, which means he or she can't legally cover you anymore. So the AHA or the Covered California, that's your kind of resource that you want to get started on, and I encourage you to start looking sooner rather than later. The last thing that the summons covers would be that we only recognize you in California as married or single. Once you've begun this divorce process, you are not divorced, which means you are still married. Even though you're in kind of this funny position, what it basically means is that the law still recognizes you as legally married until the divorce judgment is entered. What does that mean for you? Well, if you were to die without a will, that's called dying intestate, everything goes to your next of kin, and your next of kin would be, yes, your spouse, whether or not you're going through a divorce. So the warning here is basically that if you are concerned, you can always draw up a will, you can go see an estate planning attorney and figure out what you can do. You cannot, again, change the beneficiaries. Do not change beneficiaries, do not change anything. But as far as drawing up a will, you can absolutely do that. And that takes us to the end of page 2 of the summons. Like I said, pretty easy form to do, but it has a lot of legal meaning and a lot of legal warnings. So if you have any questions about what these standard family law restraining orders mean, whether they apply to you or not, the answer is yes. Please contact an attorney or please view my website for more information. So we've just finished the summons, which is Form FL-110, and you're one step closer to being ready to file for divorce. Our third step is going to be the UCCJEA, which is Form FL-105, and that only applies to you if you have minor children of your marriage. If you don't have minor children of your relationship, then we're going to skip that video and go ahead to the next step, which would be the service, which is the Proof of Service of Summons, Form FL-115.